B. Application. The investigation uncovered extensive evidence that Paul Manafort's and Richard Gates' pre-campaign work for the government of Ukraine violated FARA. Manafort and Gates were charged for that conduct and admitted to it when they pleaded guilty to superseding criminal information in the District of Columbia prosecution. The evidence underlying those charges is not addressed in this report because it was discussed in public court documents and in a separate prosecution memorandum submitted by the acting Attorney General before the original indictment in that case. In addition, the investigation produced evidence of FARA violations involving Michael Flynn. These potential violations, however, concerned a country other than Russia, i.e. Turkey, and were resolved when Flynn admitted to the underlying facts in the statement of offense that accompanied his guilty plea to a false statements charge. Statement of offense, United States versus Michael Flynn, number 117 CR 232, DDC, December 1st, 2017, document 4, parentheses, Flynn statement of offense, close parentheses. The investigation did not, however, yield evidence sufficient to sustain any charge that any individual affiliated with the Trump campaign acted as an agent of a foreign principal within the meaning of FARA or in terms of Section 951, subject to the direction or control of the government of Russia or any official thereof. In particular, the office did not find offense likely to prove beyond a reasonable doubt that campaign officials such as Paul Manafort, George Papadopoulos, and Carter Page acted as agents of the Russian government or at its direction, control, or request during the relevant time period. Redacted personal privacy. As a result, the office did not charge, redacted personal privacy, any other Trump campaign official with violating FARA or Section 951 or attempting or conspiring to do so based on contacts with the Russian government or a Russian principal. Finally, the office investigated whether one of the above campaign advisors, George Papadopoulos, acted as an agent of or at the direction and control of the government of Israel. While the investigation revealed significant ties between Papadopoulos and Israel, and search warrants were obtained in part on that basis, the office ultimately determined that the evidence was not sufficient to obtain and sustain a conviction under FARA or Section 951. 3. Campaign finance. Several areas of the office's investigation involved efforts or offers by foreign nationals to prove negative information about candidate Clinton to the Trump campaign or to distribute that information to the public to the anticipated benefit of the campaign. As explained below, the office considered whether two of those efforts, in particular the June 9, 2016 meeting at Trump Tower, redacted, harm to ongoing matter, constituted prosecutable violations of the campaign finance laws. The official determined that the evidence was not sufficient to charge either incident as a criminal violation. A. Overview of governing law. The United States, quote, the United States has a compelling interest in limiting the participation of foreign citizens in activities of democratic self-government and in thereby preventing foreign influence over the U.S. political process. End quote. Blumen versus FEC 800F, Supplement 2D 281 288, DDC 2011. Finance law broadly prohibits foreign nationals from making contributions, donations, expenditures, or other disbursements in connection with federal, state, or local candidate elections, and prohibits anyone from soliciting, accepting, or receiving such contributions or donations. As relevant here, foreign nationals may not make, and no one may, quote, solicit, accept, or receive, unquote, from promise to make a contribution, from them, quote, a contribution or donation of money or any other thing of value, unquote, or, quote, an express or implied promise to make a contribution or donation in connection with a federal, state, or local election, unquote. 52 U.S.C. 30121A1A, A2. The term contribution, which is used throughout the campaign finance law, includes, quote, any gift, subscription, loan, advance, or deposit of money or anything of value made by any person for the purpose of influencing any election for federal office. 52 U.S.C. 30101 8AI. It excludes, among other things, quote, the value of volunteer services, unquote. 52 U.S.C. 30101 8BI. Foreign nationals are also barred from making, quote, an expenditure, dependent expenditure, or disbursement for an electioneering communication, unquote. 52 U.S.C. 30121A1C. The term expenditure includes, quote, any purchase, payment, distribution, loan, advance, deposit, or gift of money or anything else of value made by any person for the purpose of influencing any election for federal office. 52 U.S.C. 30101-9A1. It excludes, among other things, news stories and nonpartisan get-out-the-vote activities. 52 U.S.C. 30101-9BIII. An independent expenditure is an expenditure expressly advocating the election or defeat of a clearly identified candidate. That was a quote. And made explicit and made independently of the campaign. 52 U.S.C. 30101-17. An electioneering communication is a broadcast communication that refers to clearly identified candidate for federal office and is made within specified time periods and targeted at the relevant electorate. 52 U.S.C. 30104 F3. The statute defines foreign national in quotes by reference to FARA and the Immigration and Nationality Act with minor modification. 52 U.S.C. 30121B. Cross-referencing 22 U.S.C. 611B 1 to 3 and 8, U.S.C. 1101A 20, 22. That definition yields 5, sometimes overlapping categories of foreign nationals, which include all of the individuals and entities relevant for present purposes, namely foreign governments and political parties, individuals outside the U.S. who are not legal permanent residents, and certain non-U.S. entities located outside of the U.S. A, quote, knowing, brackets, and willful, two brackets, end quote, violation involving an aggregate of $25,000 or more in a calendar year is a felony. 52 U.S.C. 30109 D1AI C Blumen, 800F, supplement 2D at 292, parentheses, noting that a willful violation will require some proof of the defendant's knowledge of the law. United States versus Danielzik, 917F, supplement 2D, 537, 577, ED, VA, 2013. Parentheses, applying willfulness standard drawn from Bryan versus United States, 52 U.S. 182, comma 19192, 1998. See also Wagner versus FEC 793F 3D 1 19N 23 DC circular circa 2015 parentheses N bank parentheses same. Quote, knowing double brackets and willful double brackets, end quote, violation involved an aggregate of $2,000 or more in a candidate year, but less than $2,500 is a misdemeanor. 52 U.S.C. 30109 D.I.A.I.I.